The title of my thesis is The Roles of the Judiciary in Commercial Arbitration as outlined in Ethiopian Proclamation, Proclamation 1237/2021. It is a comparative analysis. The first topic is a general overview. Arbitration is a form of dispute resolutions that delivers binding decisions, unlike other ADR mechanisms. Unlike other alternative dispute resolution mechanisms, arbitration is a form of ADR that delivers binding decisions. Despite its private nature, national courts play an essential role in various stages of commercial arbitration process. Prior to the Arbitration and the Conciliation Working Procedure Proclamation 1237, Ethiopian courts had a broader role in arbitration proceedings. This study examines the role of Ethiopian courts in arbitration process under the proclamation, comparative analysis with unilateral model law, and the New York Convention highlights challenges in implementing the court's role. Another general overview is recommendations are offered to address challenges and improve the efficiency of the arbitration system. A doctrinal legal research method is used to analyze the proclamation and the relevant international instruments. The study reveals that the role of Ethiopian courts in commercial arbitration has been significantly reduced, promoting autonomy and efficiency in dispute resolution. Comparative analysis with unilateral model law and the New York Convention highlights the challenges in implementing the court's role. The other topic is statement of the problem. National courts play a crucial role in arbitration, but their involvement must be balanced with the need for efficiency. Ethiopian courts had an overreaching role in arbitration before the proclamation, which goes against the purpose of arbitration, which means before the enactment of the proclamation, the court's role in arbitration goes against the purpose of arbitration, which means the courts were too involved in arbitration proceedings, which undermines the purpose of arbitration as an alternative to litigation. The judiciary in Ethiopia faces challenges in commercial arbitration, including lack of a clear legal framework, specialized training for judges, lack of specialized training for judges, and the lack of awareness among judges and stakeholders. These challenges impact the efficiency and effectiveness of commercial arbitration in Ethiopia. Despite Proclamation number 1237/2021 2021, there is a need for empirical research on judiciary's role in commercial arbitration and a comparative analysis with other jurisdictions. The research problem is to investigate the judiciary's role in commercial arbitration in Ethiopia, to identify challenges, and to propose solutions to enhance effectiveness. The thesis aims to explore the challenges faced by the judiciary, propose solutions, and compare the role of Ethiopian judiciary with others. The other topic is literature review. The role of the judiciary in commercial arbitration has been extensively studied with debates on the advantages and disadvantages of arbitration compared to traditional litigations. Arbitration is seen to offer benefits such as speed, efficiency, confidentiality, and fair outcomes. But concern exists regarding bias, lack of transparency, and perceived inequality regarding the arbitration. The answer is Ethiopian arbitration law is, compared to international standards like Unilateral Model Law and the New York Convention, which provides a standardized framework and facilitates global recognition and enforcement of arbitral awards. Despite Ethiopia's positive step in aligning with international standards, disparities persist in courts' intervention, in terminology, reciprocity principles, public policy consideration, and procedures for executing arbitral tribunal. The specific role of Ethiopian courts under the proclamation is underexplored, prompting a need for in-depth analysis to bridge the gaps between domestic arbitration laws and international standards. Recommendations for harmonization are essential to enhance Ethiopia's arbitration framework, boost investor confidence, and improve the efficiency of dispute resolution in the country's commercial landscape. Research objectives. The research objectives of my thesis is first, evaluating proclamation and the judiciary's role. Second, examining jurisprudence and the judiciary's role. Third, analyzing the impact of unilateral model law. Fourth, identifying challenges and proposing solutions. And finally, comparative analysis and public policy development. Methodology. Under methodology, the study employs a qualitative, partly doctrinal, or pure legal research approach. It involves first, a qualitative analysis of conceptual foundations. Second, descriptive method to elucidate the legal framework regulating arbitration. Data analysis includes analysis of the proclamation and other relevant international instruments, comparative analysis of the judiciary's role in commercial arbitration in Ethiopia and other jurisdictions. Expected outcomes. This thesis aims first to provide a better understanding of the judiciary's roles in commercial arbitration in Ethiopia. Second, compare the judiciary's role in commercial arbitration in Ethiopia with other countries and the model law. Fourth, offer recommendations for improving the judiciary's role in commercial arbitration in Ethiopia. The major foundings. The foundings of this thesis are first, the discrepancies in terminology and procedures between the Ethiopian Proclamation 1237/2021 and the unilateral model law. This discrepancy in terminology is found in Article 8, verse 2 of the Proclamation and Article 8, verse 1 of the model law, the unilateral model law. These terminologies are: the first describes void and ineffective, and the second, which is the model law, described null and void, inoperative and incapable of being performed for the courts not entertaining the arbitration agreements or arbitration agreement is the court may refuse to hear the cases where the arbitration agreement is void and become ineffective. But the model law used null and void, inoperative, or incapable of being performed. From this, the model law provides broader exceptions. The model law provides broader exceptions regarding the scope of arbitration agreements, while the Ethiopian Proclamation's exceptions are more specific. Additionally, the model law uses distinct terms for each exception, whereas the Ethiopian Proclamation uses the term void to encompass all situations. The other is discrepancy in challenging arbitrators. Unilateral model law allows proceedings to continue, while the Proclamation grants courts authority to stay proceedings. These are found in Article 13, verse 3 of the model law and Article 15, verse 5 of the Proclamation. From the unilateral model law, Article 13, verse 3 allows continuation of the proceedings, while the Proclamation suspends the proceedings when there is a case at the stage in the court based on challenging arbitrators. Furthermore, the Proclamation's incorporation of the principle of reciprocity for refusing to enforce foreign arbitral awards may have a negative effect on the enforcement of arbitral tribunals. Another, the lack of comprehensive provisions regarding public policy exceptions in the Proclamation creates unambiguity and subjectivity of the enforcement of foreign arbitral awards. There is no comprehensive provisions that explore what public policy means or what public policy constitutes. Therefore, this paves the way for judges to decide arbitrarily, or it may be subjective to the judge to judge. Finally, the absence of specific provisions for executing arbitral award in the proclamation. The proclamation didn't provide any specific provisions how to execute arbitral awards. On the other hand, it refers to the civil procedure law, which is too old and which may not align with the principles in unilateral model law and the New York Conventions. Conclusion: arbitration is a private and consensual method of dispute resolution suitable for business disputes. Despite its private nature, arbitration processes often involve courts in varying degrees. Courts may involve in arbitration in different stages. Proclamation 1237/2021 tries to modernize Ethiopian law and align with international practices in commercial arbitration. The proclamation also outlines the roles assigned in Ethiopian courts in arbitration proceedings. The Federal Supreme Court Cassation Bench has jurisdiction over all arbitral awards unless specifically excluded by the parties. Ethiopia generally abides by the guidelines of the United Nations Conventions on the recognition and enforcement of arbitral awards. The proclamation does not introduce a distinct procedure for executing arbitral awards. The incorporation of a reciprocity principle in foreign awards also may discourage parties from choosing Ethiopia as the venue for enforcing arbitral awards to arbitration. And finally, we can conclude that Ethiopian courts have been assigned minimal and supportive roles in arbitration proceedings, and this aligns with the best practice for court intervention in arbitral processes. Finally, recommendations are also provided in order to enhance the effectiveness of the courts in commercial arbitration. The following recommendations are put forth for improving the arbitration and conciliation working procedure proclamation, Proclamation 1237/2021. The first is the legislator should amend Article 8, Verse 2 of the Proclamation to align with the unilateral model law. As it contradicts or as it is not aligned with the model law, it should be amended. The second is to adopt the provision of Article 13, Sub-Article 3 of the unilateral model law for more efficient arbitration process. Here also, The legislators should keep in mind that they should adopt the provisions of Article 13, verse 3 of the Unilateral Model Law. Fourth, revisit and align the reciprocity principle with international standards to enhance Ethiopia's appeal as a jurisdiction for arbitration. Fourth, again also, the legislator should revise Article 53, Subarticle 2F to provide clarity on public policy exceptions for the enforcement of foreign arbitral awards. Finally, it is better to establish dedicated working procedure for execution of arbitral awards aligning with the principles of unilateral model law and the New York Convention. The significance of this thesis can be outlined as follows. First, this study contributes to the understanding of the unilateral model law and the New York Convention in Ethiopian commercial arbitration. It contributes to the understanding of the unilateral model law and the New York Convention in Ethiopian commercial arbitration. Second, the findings will offer valuable insights for policymakers, legal practitioners, and the businesses in Ethiopia. This study also aims to enhance the efficiency and effectiveness of commercial arbitration in the country. Thank you very much.